Alex here with part 32 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, however, number 1, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number 2, the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We left off in part 30 with my review hearing, which was my first real taste of representing myself in front of a duly elected district judge. There were a couple of other videos where I was in front of a domestic master, actually just one video. And there was a prior moment, which was in part 27 when I was in front of the district judge, but it was just for a settlement conference. So he didn't really have the power that he had in this hearing, and the reason why is because at settlement conferences it's all about what you guys agree to, and if you don't agree, then that's it, you just move on from that point. Whereas in a review hearing there is the potential that a judge can enter orders over your objection, and then of course the only thing that is really more, I guess, stressful than that would be an evidentiary hearing or a trial, which hasn't come yet, and it won't be coming for a while, and that is because I ended up getting everything that I wanted at that review hearing. I wanted joint physical and joint legal custody, and my ex conceded that the visitation, that the timeshare that I had was substantial, that I should continue to have it, and because it constituted at least 40% of the timeshare schedule over the calendar year, then under existing law, I was entitled to joint physical custody. Joint legal custody was never really, I guess you could say, one of those things we were disputing. There were a whole lot of other really small issues that we were disputing that we discussed at mediation. And it just came down, I think this was the mediation where we ironed out some of the details with like the holiday and the visitation. But the big stuff was already decided at the review hearing. And I can't remember, but I don't doubt that my ex tried to continue to argue custody at the mediation. And the only reason I say that is because that's pretty much the angle she took throughout the entirety of the litigation process. It included mediation, settlement, anything that didn't have to do with litigation. She still used that as an opportunity to extend the litigation, which is, it's just something that she just couldn't help, in my opinion. Honestly, that was just the way that she thought it was all supposed to work. She didn't really know the reality of how some of these different pieces of the puzzle actually work. So whether or not she did doesn't matter, because the judge indicated that he was going to order joint physical custody so long as my timeshare remained what it was. And the prior video, which was part 31 of the My Docket series, which was a little bit of an oddball because we did go over an order, and it wasn't the order after the review hearing. So the order that we discussed in part 31 was not the order that came from part 30. That was actually the order that came from part 27. The order that we're going to go over now in part 32 is the order that comes from that review hearing in part 30. So all of that being said, let's go ahead and take a look at what our judge has filed. Here we have the order after hearing, and unlike the other order, this is the order after the review hearing. This order is going to constitute the final judgment in this case, and there is some significance to that. The first thing that I want to mention is that the final judgment indicates the end of the case. It's over, it's closed. However, unlike a normal lawsuit, it often continues on for years in a high conflict child custody case. And the reason why is that in a normal lawsuit, there are only a few things that a party can do post-judgment. Usually it's taxing costs or going after attorney fees. There are sometimes parties that want to get relief from that final order, and they might file like a motion for a new trial or something along those lines. There are very specific things that can be done in an ordinary lawsuit after the judgment has been entered. They're called post-judgment proceedings, post-judgment papers. In a child custody action, it can go on forever and ever. It can go on for 18 years, sometimes even longer than that. And that is because of the change of circumstances doctrine. I don't even know if it is a doctrine. I just know that it's a thing that happens all the time in high conflict child custody situations. People claim that there is a change of circumstances and they use that to modify child support and or child custody. And that is one of the things that's going to be going on for the remainder of the series. So it's interesting that we are here at part 32 and the final judgment has been entered, but I wouldn't be surprised at all if we ended up well into part 110, 120 by the time this was completely over, which speaks volumes as to just how convoluted and inane post-judgment proceedings can be in a child custody case, specifically a high conflict child custody case. There could be 15, 16, 17 different motions to modify child custody, all post-judgment motions to modify. There could be 6, 7, 8, 9, 10 motions to modify child support. The sky's the limit, really. And I do want to mention that this is the final order in the case. The case is closed after entering this order. This basically waives the trial. There's no need for a trial where my ex agrees to what it is that I am being given and where what I am being given constitutes what I was asking for in the pleading, the initial pleading that I filed. So those are basically the two ways that you can sort of cut off or avoid having to go to trial. The first way is if you're just entitled to what you're requesting because the other party agrees and or there's some kind of a legal basis. They have these other mechanisms in place like motions to dismiss, motions for summary judgment. I won't go into those in this video, but I do have other videos on those topics. And then, of course, the second way is you just getting what you want. If you have filed a pleading asking for certain things and you're given what you want, there's no need for a trial because you've got it. You don't even have to go through that. So for me, I got what I wanted. And for my ex, she made concessions. She agreed to certain things. And that took those out of dispute. Once they were taken out of dispute, there is no longer a basis to hold a trial. And so this is it. This is the end of the case. And I'm just saying that that's in a technical sense because in real life, the case will go on. There will be a multitude of post-judgment motions filed to modify anything that you can think of, child support, child custody, behavioral orders. There will also be a few times that she typically goes for attorney fees. And we're just going to end up having to take a look at those as they come in this case. But I wanted to also mention one more thing. I am mostly certain, but I am not 100% sure, and I would be surprised if this turned out to be wrong. But as far as I know, all of the orders that have been entered in this case up to this point, those are the interlocutory orders in this case. Some of them are temporary orders with regards to custody. Other orders may have to do with like scheduling and discovery. But my understanding is that all of those orders are basically set aside. They no longer have a point to them. And that anything that actually is intended to control going forward is entered into this final order. If there's an attorney watching, definitely correct me if I'm wrong. But my understanding is that anything that was in place temporarily, it should be in this order if it's intended for it to continue on in perpetuity as part of, the permanent order. And if it's not entered into the permanent order, then my understanding is that that just wasn't intended to be something that continued on after the point of the case having been closed. That whatever it was that wasn't included in the order was just temporary in nature and it's basically gone. Now, I hope that this is the way it works because I can imagine it can get confusing if not, but I am not 100% sure. So just keep that in mind. If you are fashioning a final judgment or decree of divorce final order in your case, I'm not sure. So you should look into whether or not, you should always look into something even if I'm sure, but you should look into whether or not any temporary provisions need to be included into that order. Maybe to play it safe, you should ask for them to be included in the final judgment or order. Because if you don't do that, you may end up in a situation where your ex says, hey, that doesn't matter anymore. Our case is closed, and only the stuff that's in the final order is the stuff that we need to abide by. So let's go ahead and get started here. First paragraph. I think it's odd that it refers to the settlement conference because this order was entered pursuant to the review hearing. It's possible that my ex's attorney's paralegal just opened the previous document, which was the order entered after the settlement conference, and that they forgot to backspace that out and replace it with the review hearing. But it's also possible that they intended it to be this way because the review hearing was, in a way, a sort of extension of the settlement conference. If you remember correctly, what came up at the settlement conference was my ex's mental health records. And so when those mental health records were discussed, the court indicated that it was going to be difficult to continue to explore settlement without knowing what was in those documents. So in a way, it could be considered to be an extension of the settlement conference. And if that's the case, then the paralegal or the attorney herself, if she's the one that prepared the order, did in fact mean to mention the settlement conference in this first paragraph, which is a summary paragraph, and the rest is pretty standard. It indicates that I am appearing representing myself. My ex is appearing through and by our attorney. The next sentence or next paragraph is what I have been fighting for months. This is what ended all of the anxiety. This is what I was fighting for, what I would not give up for, what my ex's attorney tried to psych me out of asking for, fighting for. It is the joint legal and joint physical custody. And I remember being really emotional when I got this, when I read that first paragraph and I saw that I had finally gotten it, even though I didn't have an attorney, even though I was all alone and I wasn't getting any support from like friends and family. And that was my own choice. It wasn't as if I asked and they refused to help me. I didn't even ask because I didn't want to burden them. And to see that in black and white, especially having spent so little in attorney fees, it was a real moment for me, and it was something that really boosted my morale going forward. Now, I cannot pretend that was something that persisted for a very long time, because it wasn't long at all for my ex to not only resort back to her original antics, but she actually got quite a bit worse, because for some time she had this idea that everyone was wrong and she was going to prove it. The problem was that I wasn't really filling the narrative that she had kind of given everyone with regards to the type of father I was. And so in her mind, since I wasn't doing bad things, she was going to have to find a way to create a situation where either I would actually do bad things or where she would make it appear as such. But we'll talk about those as they come up in the series, because we're not at that point yet. Second paragraph is the visitation schedule. As you can see, Wednesday to Friday at midnight, and then again Friday to Sunday, once again at midnight. So we're talking 2 midnight exchanges for a 2-year-old child. I am hoping that this is not something that goes on for very long, but as I have told my viewers, it goes on for several years. And as those other attempts by me to modify the schedule come up, we can discuss that more and more. But for now, I do want everyone to be aware that these are overnights that I am entitled to. I get one Wednesday night, I get another Thursday night, and in a way, I kind of get one half a Friday night, but then, it's midnight, so it's like half an overnight, or it's not even, maybe it doesn't count as an overnight. And then I get another overnight Friday, because that's the weirdest thing that used to frustrate me. She picks him up Friday at midnight, only to give him back to me Friday at 3 p.m. So I do, in a way, get another overnight there on Friday, and then one more after that on Saturday. So a whole lot of overnights for me. Good chunk of time for me to spend raising my son. I'm very happy with this schedule at the time, because I naively do not understand just how long this is going to persist for. Exchange point, I don't know if there's much a point talking about this. It's we've already kind of gone over the fact that we have to exchange at third party locations. I think we've mentioned Wendy's. I know that later on it changes to Denny's. I can't remember when this occurs. This here is the emergency designee that my ex can drop our son off at. It's an individual here Just a good friend. There are, let's take a look here. This is indicating the holiday and visitation. No, wait, the holiday. This is not really too important to me. If anyone has any questions about the holiday schedule or the holiday visitation, you can go ahead and post it down in the comments below. You can also download this document. Down in the description, there's going to be some links. There always are. So anytime you're watching any of these videos and you want to look over some of the documents and ask detailed questions, you can definitely do that. But the holiday visitation and the vacation, here go the vacations right here. This isn't something that becomes an issue right now. It's going to become an issue later on, and when it does, I'll go ahead and bring it up then. But for now, I'm going to skip over these parts. More holiday visitation. Here's the part where the judge changed the time as far as when my ex can call, and he moves it back to 7:30 p.m. And I don't even know why they mention the specific days that this can be done. It's weird to me because it's kind of obvious that you would be making calls when the child is not with you. But she puts that in there too for some weird reason. The calls actually end. Once I get joint physical custody, she doesn't really bother to call anymore. He just stops. I think she was just using it as a basis to try to deprive me of physical custody. Once I got physical custody, there was no longer a point to it in her eyes. And so she just stopped calling. No making disparaging remarks is pretty standard. I actually have a video on that. It's called the non-disparagement clause. Here's a portion about tape recording each other's conversations. I actually talk about that a lot in part 27, so I'm not going to talk about it all over again right now. But if you're curious as to my feelings on that, watch part 27 of the My Docket series. I talk about it there. We've got sharing telephone numbers and names of babysitters. We've got health insurance, paying half of the premiums. We've got providing on, this is the 30/30 provision here. The 30/30 provision requires a person who incurs out-of-pocket medical expenses to notify the other parent of those expenses within 30 days, and upon having notified them, to get their money, their reimbursement, within 30 days of that point. So 30 days to tell them, hey, I have some expenses I want to be reimbursed on. And then 30 days for that parent having been told to actually make the payment. This becomes a huge, huge issue, but not right now. So I'm going to hold off. We're going to wait until that happens in the My Docket series, and then we'll talk about it then. In-network healthcare providers. I have to admit to my viewers, this was not my idea. I think it was my ex's attorney's idea. And this is something that saved my butt. And I tell all of my viewers, do not allow your ex to incur out-of-network medical expenses with impunity, because if you do, they will do it on purpose just to cause you to have to spend multiple $1,000s each time to take a child to get some medical care. So it's a great idea to have this included into a provision requiring the parties to use an in-network provider whenever possible. And if they fail to do so, they get no reimbursement. Next section, we've got the Rivero v. Rivero citation. What? This is wrong. Well, I mean, Rivero does mention Wright v. Osborne. This actually, or does it? I'm going to hold off on saying that because I don't think Wright v. Osborne uses that specific portion of the formula that was taken from Missouri. And there is a portion of the Missouri formula that requires taking into account the specific percentage of the timeshare between the parents. Now that I'm thinking about this, I do not think Wright v. Osborne requires that little percentage, that one extra factor to be taken into consideration. So it probably is coming from Rivero v. Rivero 2008. In Rivero v. Rivero 2009, that is expressly discussed by the Supreme Court. They do not like it, and so they remove it from the Nevada case law. And then we end up back on the Wright v. Osborne formula for anyone who's on joint physical custody. If anyone has any questions on that, feel free to watch my video, Child Support. And this is another weight off my shoulders right here. My ex has been ordered to begin to pay me child support. So for several months, it was difficult, but I made it happen. I mean, I got the money together, I paid child support, I caught up to my arrears, and eventually the judge suspended my child support obligation, so I no longer had to pay child support. Here we are, and the judge is now ordering my ex to pay child support to me in the amount of what looks to be $151.08 per month. This amount will change a couple of times in the future. It's going to go up and up. But right now, we're going to hold off on going any further. We'll wait until those other videos come up in the My Docket series, and we can discuss how and why child support is being increased. Looks like something about 30 days proof, or provide proof within 30 days that both of us have attended the parenting classes. This is something that kind of got under my skin a little bit, because I attended the class and I got proof of it. My ex never did. And it got under my skin because it was that same attitude of, you need to do things to get better. I don't need to do anything. And I don't know, maybe going forward, we'll see if I bring that up or not. But I really don't think the court cares. I mean, we end up coming back to court so many times, and it just doesn't seem to be something that jumps out at me. Thinking back 9 years, I don't remember the court really caring about that. So maybe it wasn't a big deal, or maybe I just didn't think it was worth bringing up. Maybe there were so many other worse things to talk about. The next provision here I've talked about before. This is the boilerplate, standard boilerplate. It's required to be included in any child custody order that's entered in the state. It's required by law, and it is inserted into these court orders verbatim. It talks about how you're not allowed to abduct, conceal a child, detain a child in violation of this order, and it makes it clear that it's a Category D felony. And then at the very bottom, we're put on notice as to the terms of the Hague Convention. This is for people who flee with a child outside of the country. They'll go to another country and hide and escape the jurisdiction of the United States. Basically, it is a technique that some parents use to wrongfully detain their child in a foreign country. Interesting, I signed this one. So it looks like my ex's attorney signed it as a submitter. I signed it as approved, and I didn't find any problems with this proposed order, so that's good. I will have some issues with proposed orders in the future, however, so we will continue to see this fight occur. If anyone hasn't seen my video, Proposed Orders, it's a must-watch, so go ahead and take a look at it. Here we have the request for submission. This was filed by my ex's attorney, and it is submitting the order after entry, the proposed order, to the court. Nothing really jumping out at me. Certificate of mailing indicating that she mailed this request for submission to me, and the proposed order, which I approved. Obviously, I signed it. Here we have the notice of entry of order. Okay, so this would have been entered. Okay, I get it. This was filed after the court entered that proposed order. So the last document was my ex's attorney submitting it to the judge. And then the first document we went over was the order itself as signed by the judge. And this document here is my ex's attorney's notice of entry of that order. This probably sounds like it's pointless to my viewers because, number one, I signed that proposed order, so I agreed to it. And number two, the judge mailed it to me as well. So why provide notice of entry of an order? I talk about why in the video titled Notice of Entry of Order. It's actually connected to the deadline as to when somebody can file an appeal. I'm not going to talk about that anymore because I've talked about that so many times, and I have a video dedicated to Notice of Entry of Order. So I just want to let my viewers know it's a good video to watch, and it may apply in your state too, so take a look at it. Here we have the list of exhibits. Now, since Exhibit 1 is the order after hearing, which we've already gone over, it's the first document we went over in this video, I'm not going to go any further just to look at the exact same document again. So I'm going to just move on to the withdrawal of attorney. This document indicates that my ex's attorney has withdrawn from the case. My ex is now an unrepresented party. It won't be long before her attorney reappears on this case, however. So for now, my ex's attorney has withdrawn, but she'll be back very shortly. And these documents, these withdrawals can't be filed anytime. They have to be filed at a specific point in the case, and I think the end of the case or the entry of the final order in the case is one of those opportunities where an attorney can file this document. Ordinarily, like if you have, I guess I wouldn't even use the word ordinarily. If you're like in the middle of your case, it's not as easy for the attorney to just withdraw. They have to ask the judge for permission to withdraw. Another way to get around that is by filing a substitution of counsel, but to do that, they need another attorney who is willing to sign on the dotted line and take over the case. If they do that, then they don't need the judge's approval. The other attorney substitutes into the case, and the case continues on seamlessly. This is my ex's attorney notifying both myself and my ex that she is withdrawing from the case. So for me, this is indicative of the fact that I can no longer go to my attorney's office, or my ex's attorney's office, to have my ex served. Now I have to find a way to serve my ex herself anytime I want to do something in the future. This here's the affidavit of service that I filed. I'm not sure why I filed it. It looks like I just wanted to communicate to the court that I took the proposed order after approving it and gave it back to my ex's attorney. But like I mentioned earlier, there's no point to this document. It didn't have to be filed, and I shouldn't have filed it. But that's the best I can do is speculate to what I was thinking back then in 2009. And having, only been representing myself for a short while, typically when I wasn't sure about something, I would err on the side of caution. And if that meant filing unnecessary documents, that's what I would do. Ultimately, you're going to want to move past that. And I do. But at this time, and probably for a few years, there will be some documents that I take a look at and I'm like, what was I thinking there? What was I doing? And I'll go ahead and let you guys know. This is the affirmation. I just included it on the next page, which I've gone over quite a few times, but just lets the clerk of the court know there's no social security number in this document. Going into the aftermath, the district judge disposed of the pleadings filed in this case. The pleadings are the petition that I filed to open the case requesting joint physical and joint legal custody, and the answer and counterclaim that my ex filed in response to my initial pleading requesting primary physical custody and joint legal custody. I vaguely recall her asking to keep me out of supervised visitation, if I remember correctly, but it doesn't matter because that didn't happen in the end anyway. And I think the reply to counterclaim that I filed also constitutes one of the pleadings. Now, the district judge awarded joint physical custody and joint legal custody and gave substantial amounts of visitation to both of us unsupervised. The financials are a little bit more grueling. There were 5 documents filed. The only document that I filed was the affidavit of service, and that's a free filing, so I incurred $0 in costs. My ex's attorney filed a request for submission, a notice of entry of judgment, and the withdrawal of attorney. Those are all free filings, so she incurred $0 in costs as well. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, let's take a look here. Let's go over the short ones quick. So the request for submission, that's one of those form documents that are paralegal, probably just has to backspace a few of the details out, like dates and probably the caption, stuff like that. 5 minutes is what I think she probably put into the request for submission. Notice of entry of order, same thing, with the exception that she takes a stapler and staples an exhibit to the back, which is the order that the court entered. So that's another 5-minute document, in my opinion. The withdrawal of attorney, again, another one of those form documents. They all look the same. You just have to change the details, case number, sign it. So we're talking another 5 minutes. So those 3 documents, I think she probably charged 15 minutes of work for. Reviewing my affidavit of service, I doubt she even bothered because there was no point to it. So I'm just going to say 0 minutes for that. And then we've got the order after hearing. She did have to review this and communicate it to her client. She probably has already talked to my ex about the details of that order long before it was actually entered by the court, because she had to prepare the order and then send me the proposed order. And then, of course, she probably debriefed her after Part 30, after the hearing. So let's say just 15 minutes to review that order, which comes to a total of 30 minutes at a rate of $250 an hour. I'm sure that would have come to somewhere close to $125 in attorney fees for my ex. If you have any questions, feel free to post something down in the comments below, and I will see you guys next time.